Hello guys, and welcome to another episode of our civil litigation mock trial course by the DECO Daniels School of Law. And on today's episode, we are talking about the draft for third-party proceedings. The draft for third-party proceedings, right? I already taught you the substantive class, right? The class itself, when I was teaching parties to a civil action. That's our module 3 for the civil litigation course, right? I already taught parties to a civil action, right? And while I was teaching it, I taught you what we mean when we say third party proceedings. But in this class, we are focusing on how we properly draft, right? For the sake of law school and bar finals, how we properly draft third party proceeding, the application for it. Right? How we are supposed to draft it. I can remember that while I was teaching you the class, I told you that, one indicia or one insignia of how we can determine if we are supposed to have a third-party proceeding application in exam. When they tell you what you are supposed to draft, they tell you to draft something, you don't know what to draft. But how are you able to know that this thing that you ought to draft is third-party proceeding? Is where they tell you that somebody is going to be liable for something, right? And then another person is supposed to bear the liability, right? Like in the case of insurance company. Somebody was driving on the road, he has insured his car. He was driving on the road and then he hit his car on another car, right? Now, there is a third-party insurance that if anything happens to my own vehicle, this insurance company will cover all the damage. And if anything happens to a third-party vehicle, and I'm the one who caused that thing to happen to a third-party vehicle, then the insurance company will also cover the damage for that third party. Now, that other party, now let us say that I'm Mr. Tajuddin, right? And then the other party here is Mr. Emeka. So, Mr. Tajuddin, that is me, I am driving on the road one day and I mistakenly hit the car of Mr. Emeka. Now, Mr. Emeka, being an Igbo man that doesn't joke with money, then asked Mr. Tajuddin, what kind of rubbish is this? What do you mean? What do you mean you did not see me on the road? Didn't you see traffic light? Didn't you? Wishad did a lot of wahala on that day. He carried me to court. How is it going to be Mr. Emeka, who is the claimant, versus and Mr. Tajuddin, who is the defendant, that is me in this case? Now, I, Mr. Tajuddin, who know that not only have I insured my own car against damage, I have insured third-party vehicles, right? In the case where I hit a third party, I have insured all those people that I might hit in future, right? And then this insurance company is supposed to also pay the damage that might cause on any third-party vehicle because I've insured, right? Now, during the course of the trial, I then realized that, I go bear eventual liability for this matter. Make I kuku tell this my insurance company, may they join this suit. So you now, as the defendant, which is what distinguishes, one of the distinguishing mark between a third party and joinder of parties, as the defendant, you then join that person who is going to bear eventual liability. A claimant can join in joinder of parties, but in a third-party proceeding, a claimant cannot join for third-party proceeding. It is only the defendant that can join, because it's the defendant that knows that, yes, I am liable in this case, but it is not me that will pay that liability. It is this person that I want to join. The claimant cannot join the person. It is the defendant that can join. But joinder of parties, not only can the claimant join the party, not only can the defendant join the party, even the court can so much to say a party should be joined in this action. Can you see one of the distinguishing factors that we are discussing so far? I've taught all these things, right? I've given you the proper explanation for all these things. But particularly now, in today's class, we are now saying, I am Mr. Tajuddin now. And I'm saying, Jesus Christ, what do? I went to meet my lawyers. My lawyer is Mr. Dieko Daniels, of course. And then I told Mr. Dieko that, this money that they are saying that I should pay, how much is the total of it? They said 15 million. Oh God. But I have an insurance company who I already carried out insurance policies against future damages of this sort. One of which is for my car, of which they've paid, and another is for the third party. How do I make sure that they pay for this third party? And Mr. Dieko will say, oh, that is fine. Number one, just give me the insurance policy that you said you executed. Let me go through it. And after I've gone through it, I see that, yes, there is a valid contract of insurance here. Okay, no problem, Mr. Tajuddin. I think what we have to do in the course of this trial is that we have to join this insurance company as a party to this suit, right? As a third party to this suit. So we are going to file an application. So I am now saying that this application I want to file, I want you, the person listening to me, now to file this application, right? And so how do you go about filing the application? How do you draft it? That is what we're answering in this class, right? So let's go into how we draft. Now, in the High Court of Lagos State, in the Lagos Judicial Division, holding at Lagos, if you have listened to my draft classes, you will know that for every motion, this is how we start it. In the High Court of Lagos State, in the Lagos Judicial Division, holding at Lagos, or in the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division, holding at Abuja. Anyone, depending on what court has jurisdiction. How do we determine the court that has jurisdiction? I have answered that class in our Module 2 class. Do you understand? Our lectures on Module 2, where I taught jurisdiction. So please go back to our jurisdiction class. If you don't know at this point how you know what court to go and how you draft and all that, the heading of the court, then please go back to our jurisdiction class. I have talked about it. Now, after that, you then have your suit number. I have told you that for every of your motion, for the sake of both law school, both practice, and our course here, you are supposed to have your suit number. He has marks at law school. He has marks at this our course here, and also our practice. If you don't have suit number, they'll be wondering, you go law school like this, and then after that, we now have parties. Now, for the parties section, this module, we've thought about this parties section, how to properly draft parties, right? Our module 3, parties to a civil suit. How to properly draft the parties section. We have taught it excellently well. And I also told you in our interlocutory application, module 8, I told you that when you are bringing an application, listen carefully. When you are bringing an application, somebody has to be designated the applicant. Somebody has to be designated the respondent. Right? I have taught you that. So in this case now, the person that can be the applicant for this application for third-party proceedings can only be the defendant. The claimant cannot be an applicant, and I've explained that already. Can only be the defendant, and in this case, we have claimant/respondent and defendant/applicant. Right? Now, like we have a similar thing when I was teaching you joinder of parties. I told you that there are 3 layers for joinder of parties, right? You have claimant/applicant, defendant/respondent, or it can switch because any of them can be applicant. And then we have the third layer, parties sought to be joined. When I was teaching you misjoinder of parties, I can remember that I told you that we don't have those 3 layers. We only have those 3 layers for joinder. We have 3 layers for joinder, but 2 layers for misjoinder. That means you want to strike out a party's name because he has been misjoined. You want to strike the name out, right? We have 2 layers: claimant respondent or claimant applicant, defendant respondent or defendant applicant, as the cases. Are you following me? Now, when I was teaching you joinder, I told you that there are 3 layers. Parties sought to be joined. Now, in third-party proceedings, there are 3 layers again. And the third layer is not parties sought to be joined, though, ladies and gentlemen. The third layer is third-party/respondent. Now, when I was teaching you joinder, did I say parties sought to be joined/respondent? No. It is parties sought to be joined, full stop. The person is not a respondent. He's not responding to the application. But this one, which is the ex parte application for third-party proceeding, the party is a respondent, as we can clearly see. Do you understand? 3 layers for joinder of parties, right? 3 layers for joinder of parties, 3 layers for third-party proceedings, 2 layers for misjoinder of parties. Please don't forget, as I'm teaching you all these things, let them stick in. Let them stick in. You will need them. Do you understand that? Now, the next thing is the heading, motion ex parte. Now, misjoinder was motion on notice. Joinder, motion on notice. Third-party proceeding, motion ex parte. Representative action, motion ex parte. Do you understand that? So, third-party proceeding is motion ex parte. Now, brought pursuant to order what? Order 15, Rule 19, right? Order 15, Rule 19, and Order 43, Rule 1 of the High Court of Lagos State Civil Procedure Rules 2019, and under the inherent jurisdiction of this court. And I've taught you countless number of times, and I'll continue to teach, that when you are bringing your broad pursuant to, right, there are 3 things that ought to be stated there. Number 1, the specific order that gave you the permission to bring a third-party proceeding. That specific order, you must write it. Number 2, the general order that says that all application shall be by motion or notice or motion ex parte. That specific order, order 43, you must state it. And under the inherent jurisdiction of this court. Those 3 things must be in your broad pursuant to. And your broad pursuant to is immediately after your motion ex parte or your motion on notice, as the case is. But since this is a third-party proceeding, then it is motion ex parte. So motion ex parte, broad pursuant to, order 15, Rule 19, and order 43, Rule 1 of the High Court of Lagos State Civil Procedure Rules 2019, and under the inherent jurisdiction of this court. I hope you are following, and I hope you understand. Okay, so then after that, we have the general clause for all motion, which by now you ought to know, which is, take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon or so soon thereafter, as counsel for the defendant applicant may be heard praying this honorable court for the following reliefs, or as counsel on behalf of the defendant applicant may be heard praying this court for the following release. Same thing, or for the following orders. Same thing. Just make sure that it follows this way. Please, let us memorize these things. Please and please, let us memorize them. You will draft it in exam. So please, memorize them. Do you understand that? Now, the order. You know that what differentiates every application from other application, particularly, is that other part, right? You know that we have the broad pursuant to. That's another distinguishing factor. What are you supposed to put? What particular order gave you the permission to bring this application? You know, you have the general order. It is in all applications, right? But what particular order, the first order that you write, what particular order gave you that permission? Then your general order, then after that, under the inherent jurisdiction of the court. But you have to start with that particular order. That's a distinguishing feature. Now, you also have to look at the party section. That party section, how do I couch these parties? Now, for some applications, they are almost always the same way you draft them. But there are some distinguishing applications. One I have mentioned now is third-party proceedings. Why is it distinguishing? Because you have 3 layers, and the third layer is third-party / respondent. Is there any other one? Yes. Joinder of parties. Why is it distinguishing? Because you have the third layer. What is the third layer there? Parties sought to be joined. Do you understand? So applications usually are almost the same, but there are certain distinguishing marks in some of these applications. And that is why I'm teaching you. And let me even give you an expo. You see, these applications that have distinguishing marks are the ones that law school are likely to question you on. The ones that have distinguishing marks, like third-party proceeding, right? Joinder, because it's like every other application, does not usually have a distinguishing mark. It doesn't even have any, right? But, law school will not really ask that question. But joinder of parties, law school will ask. Because law school wants to know, do you know that there are 3 layers? And in the order, do you know how to properly couch your order? Right? Law school will ask that. Do you understand? So third-party proceeding is another one. So how do we couch the order for third-party proceedings? It says, an order of this honorable court joining Sunshine Insurance Company as a third party in this case. An order of this honorable court joining Sunshine Insurance Company as a third party in this case. Now, there are certain instances, I have heard, right? And I've also seen that there are certain instances where they will say, we are supposed to seek for the leave of the court for that third party, this thing that you have sought for, the third party order you have sought for, to be served on the other party. That's the leave of the court for the third party notice to be served on the party. Now, it is not something that is compulsory in accordance with law school, right? It's not something that is compulsory. And I will even tell you, please and please, as you are listening to this, go and ask your lecturer. When I'm drafting third-party order in exam, I know that I'm supposed to say that an order of this court joining Sunshine Insurance Limited as a third party in this case. Should I bring another order, which is number 2? You know that the first order is number 1. Our number 2 here is our omnibus order, which is for such further order or orders. Now, should I bring number 2, where I'm going to say that an order of this court, right, for the leave, right, granting the leave to serve the third party notice on the third party in this case? Should I ask for that in the exam? Please ask your lecturers. Because I know that there's this thing that, you are supposed to serve third-party notice. You are supposed to serve third-party notice. And you are supposed to seek for the leave of the court to serve third-party notice. I asked my lecturer during my own time, and my lecturer said it's not necessary. That's why I told you it's not necessary. Right? Now, as at the time you might be listening to this lecture video, it can be such that things might have changed. Right? Especially on this area. So I would advise, please ask your lecturer to know what they want in exam. Should I, seek for leave to serve third-party notice in my motion ex parte for the third-party proceeding? Should I do that? Ask your lecturers. And also, we then have the omnibus clause. I have taught you in our module 8, interlocutory application, what the omnibus clause is and why we have the omnibus clause in every application. I've taught you that. And then we have our date. Please do not miss that. It is marked. And the counsel that is signing is an ex parte application. So you don't have on notice to or for service on. Right? You don't have on notice to or for service on because it's an ex parte application. So let's say, Dear Court Daniels, Esquire, that is Dear Court Daniels and Partners. So your name comes first, then your firm, then who you are representing, the defendant, applicant, counsel, your address, that's the address of your firm, and email and phone number. It must follow that order. And then lastly, let's just talk briefly about the affidavit, right? The affidavit that must be attached, because law school can ask you the question of your affidavit, right? That you should draft the process, right, the application and accompanying document, right, minus the written address. So if they ask you to draft the affidavit, how do you draft the affidavit? The first thing is that you replicate the first set of things that you put in your motion paper. The heading of the court is the same in your affidavit. The suit number, the same in your affidavit. Between the 3 layers, the same in your affidavit. You just copy and paste. Right? You copy and what? And you paste. Now, your heading for your affidavit is going to be affidavit in support of motion ex parte for third-party proceedings. Affidavit in support for your motion ex parte for third-party proceedings. That's what you put there. And then you now go to the first paragraph. The first paragraph, then you follow our Ngaoka rule. Right? Ngaoka. That is N, name, G, gender, A, adult, O, occupation, C, citizen of which country, A, address. If you want to, you can add R. Right? You follow that order. R being religion, for those people who do not know, right? You follow that order, and then after that, you have do hereby make on oath and state as follows, right? Do hereby make on oath and does what? And state as follows. Now, you then have the 3 layers. Who is the person that is deposing to this affidavit? A litigation secretary. If it is the person other than the claimant or the defendant, then there are 4 layers that it is non-negotiable that you must have, right? 4 layers, that is 4 paragraphs. That is non-negotiable. The first one is where you introduce yourself and tell us your relationship with either the claimant or defendant in this case. So in this case now, the person per paragraph 1 says, I'm the litigation secretary in the law firm of Dear Daniels and partners counsel to the defendant applicant in the suit. Do you understand that? So that he has introduced himself and he has told us the relationship. The second thing is where he now tells us that by virtue of your position, you are conversant with the fact. What did he say? By virtue of my position, I am familiar and conversant with the facts here in the post. You see what I'm saying? So your first paragraph, you introduce. Your second paragraph is that you tell us that by virtue of your position, you are conversant with the fact. Then what's your third paragraph where you tell us that you've gotten consent? I have the consent of both my employer and the defendant applicant himself, right, to depose to the affidavit. So, number 1, who are you, and tell us your relationship with the people here. Number 2, by virtue of the position, you are conversant with the fact. Number 3, you have the consent of your employer and the defendant, or, whoever it is. So, your employer and the defendant or the claimant, depending on whose behalf they are writing that affidavit. Do you get my point? Those are your 3 layers. Please don't forget. Don't forget. Now, if you have, now in this case, you have a 4th layer when it is such that what you have come to say here is what they told you. You do not have first-hand idea of it. It's not as if you were there, you experienced it. They told you, right? Then you must then have 4 particulars. So the 4th thing contains 4 particulars of this information that has come to meet you. So this is what we are saying, right? I don't want to get you confused. So let me just give you a little of what I'm saying again. Now, I told you that there are 4 things that you must state in your affidavit, right? If you are not the defendant or you are not the claimant yourself. Number 1, paragraph 1, you must tell us who you are and your relationship with whoever in this case. Number 2, that you are familiar with the fact because of your position. And number 3, that you have the consent of your employer and the claimant or defendant as the case is. Now, I told you that there are 4 paragraphs that are important, Abi. In the 4th paragraph, because you are not the claimant or defendant, it must mean that you must have been told certain information. When it is that you now want to tell us those certain information that you have been told, you must now, in that 4th paragraph, give us 4 particulars of that information. What are the particulars? Number 1, who told you? Number 2, where did he tell you? Number 3, what time did he tell you? And number 4, on what date did he tell you? Those are the 4 things that we must pay attention to. Right? So in this case, he says that I am informed by P.P. John Esquire, the counsel handling this matter, on so day in our office. You can put the address of the office if you want to, at so time of the following fact, which I verily believe to be true and correct. Now, you must also add which I verily believe to be true and correct. Please don't forget that. Please don't forget that. But the key things here is that you are telling us who, where in the office. You can add the address of the office, or you can just say in our office. Then you are telling us what day, and then number 4, you are telling us what time. So that is 4 particulars in paragraph 4. If you can remember that in exam. 4 particulars in where? In paragraph 4. Right? So we know paragraph 1, we know paragraph 2, we know paragraph 3, then we know that we have 4 particulars in paragraph 4. When do we use 4 in 4? We use 4 in 4 when the information that we are giving is not something that we know, but something that we were told. Therefore, we have to give 4 particulars in paragraph 4. When do we use 4 paragraphs? We use 4 paragraphs when it is that we are not the claimant and we are not the defendant, but we are deposing to the affidavit on behalf of the claimant or on behalf of the defendant. Do you understand? So we have 4 in 4. 4 particulars in paragraph 4. So in this case now we have subparagraph A, subparagraph B, and subparagraph C for paragraph 4. That the defendant applicant bought a Toyota car. B, that subsequently the defendant applicant took a third-party motor vehicle insurance policy with Sunshine Insurance Company. The certificate of insurance and receipts of payment of premiums are herewith attached and marked Exhibit A and B respectively. You can see that. So, in as much as, of course, the litigation secretary was in his firm when this defendant was doing this deal with the people, he didn't know. It was the man that told him now that Alpha, I did a deal with Sunshine. He said, okay. You know, when I was talking, I said, bring the particulars. I told you that when Mr. Tajudeen came to meet me, I told him to do what? He should bring the particulars, right? The particulars of whatever it is that evidences a contract between him and Sunshine, which is what is happening in this case here, if you can see what I'm talking about, right? So, because of that particulars, I know that if I'm going to file my application, I have to attach those particulars as exhibits. Right? And that is what is attached here. What is here? A certificate of insurance and receipt of payment of premium are attached and marked as Exhibit A and B respectively. Do you understand that? Now, by virtue of the insurance policy, Sunshine Insurance Limited should be rightful body that will bear eventual liability that may be imposed on the defendant applicant in the event of judgment. Do you understand that? So you can see how we are drafting our affidavit. Every line in that affidavit has its purpose. The first 3 lines, right, you are putting that because you are not the claimant or the defendant. The 4th line is because you are not the one that, have first-hand knowledge of this. They told you. So you have to give us the particulars. Then the sub A, B, C is what you were told. Then now, your 5th line is basically what every application must have. This application is brought in the interest of justice, or it is in the interest of justice that this application is granted. Shall put interest of justice. Do you understand? And then lastly, I make this solemn declaration conscientiously believing the same to be true and by virtue of the Oath Act. That's by virtue of the provisions of the Oath Act. Please make sure that you learn these things, right? Learn the entirety of it. It is important. Also, we now have the place where the deponent is to sign, and we have, sworn in the High Court Registry, Abuja, the date, and then before me, Commissioner of Oath. Look at the way it flows and cram the way it flows. Sworn at where? The High Court Registry, Abuja, and put the date after that. Like applications, the date doesn't come after the paragraph. The date doesn't come after deponent signature at the right hand side. The date comes after sworn at the High Court Registry of Abuja. You will now see dated this dash day. Then you will now see before me. Before me is in the center of the affidavit. Down, down, down. The last thing down, down, down. But at the center. So please don't mix them up. Right? So with that, I think we've done a very good job by learning how we draft our third-party proceedings, right? That's motion ex parte, right? We now know all the rules, right? For the sake of bar finals. So I hope that you understand, and I'll see you in my next set of classes for draft as well as other classes. Have a very beautiful day. I will see you in my next class.